Some good stuff. All right, welcome everybody to this edition of Expert Witness with John Watts and Stephen Palmieri. Without John Watts, but with special guest fill-in Ari Marcus. John is out fighting the good fight against the nefarious bad boys. Ari Marcus, he's an FCRA, FDCPA, TCPA attorney, and he loves going up against the bad boys. Ari, how are you doing today? And first of all, thank you for stepping in here. How are you doing today, buddy?
I'm doing great. Thanks for having me. Happy Veterans Day to everyone. I really appreciate you bringing me on, and I'm looking forward to the next half hour.
This could be exciting stuff. Actually, for those of you guys watching us live, put in your comments below, and we're going to talk about that. But this could be a cool show because Ari and I were talking before the show. Well, his specialty is kind of like TCPA, which is the robocalls and all that, which are some fascinating things he was sharing with me. But we were also talking FCRA, right? Because those of you guys watching credit repair organizations, that's our main law. And as we all know, the FCRA as written provides remedies, negligent noncompliance, willful noncompliance. If the CRAs or the furnishers just don't comply, like if you send them a dispute, and they don't respond within 30 days, like they've been doing, technically, there's statutory provisions for that. But there is this precedent called the Spokeo Decision from a couple years ago, I guess, Ari, huh?
And yes, it happened several years ago. Yes.
Yeah, and it basically kind of says, well, so it was interesting. So the constitutionality of the FCRA and the ability for consumers to bring claims in federal court, which federal court is basically given its authority under Article 3 of the Constitution. So they argued, well, although we may have violated the FCRA ability for the consumer to bring these claims is unconstitutional because Article 3 requires that there's a claim or controversy, to use the exact terms Ari was telling me. And so, which means, i.e., your ass needs to have been damaged in some way. So let's talk a little bit about that, Ari. I know our listeners, which by the way, actually, how rude of me, Ari. Go ahead and introduce yourself. My goodness gracious. Who are you and why should people know and love you and where do you practice? Let's start with that.
Thanks, Steve. So I'm a consumer attorney. Our main offices are in New York and New Jersey, although we practice pretty much nationally. Our firm's been doing this for 11 plus years now. And as Steve mentioned, we focus mainly on Fair Credit Reporting, Fair Debt Collection Practice Act, and Telephone Consumer Protection Act. We file class actions, individual cases in federal courts around the country. And we work with a myriad of credit repair agencies, and we have for several years, or even more than that, for 10 years now. And it's just a good connection between credit repair agencies and attorneys that we have.
Cool. So you've got kind of like the holy trinity, as they would say. You've got FCRA, FDCPA, and what's the third one here? I'm having a brain freeze here. The robocalling. What do we call that?
The TCPA, the Telephone Consumer Protection Act.
So let's just kind of start at a high level. Oh gosh, we're all over the place, Ari. We'll get back to Spokeo, guys. Just bear with us. That's why y'all watch this show, because it's just raw and uncut and unscripted, and you just never know what Steve is going to say next. So let's go to the holy trinity here. Why do your type of attorneys always love those three laws together? Let's talk about that. How do they go together like peanut butter, bread, and jelly?
That's a great question. So there's a good connection between those three statutes because typically a consumer who's getting collection letters will have potential Fair Debt Collection Practice Act cases. And once you know somebody's in debt and getting collection letters, a lot of times they have issues with their credit report. So we'll ask to see their credit report. And at the same time, if you're getting collection letters, you're most likely getting collection phone calls and maybe other unsolicited phone calls. So we find a lot of our clients, as they come in, they have potentially three different areas that we can look at and attack the debt collectors or the furnishers for them to assist them. The other positive thing about it is we work strictly on contingency, may not be the right word, but we don't charge our clients any money And under the Fair Debt Collection and Fair Credit Reporting Act, the statute requires the debt collector or the credit bureau or furnisher to pay our attorney's fees. So these are type of statutes that we never charge our clients any money for. We cover all expenses. And lastly, these are all federal statutes. So we get to mainly be in federal court, which is, I guess, a good segue to what Steve was just talking about with Spokeo and then the recent Ramirez Transunion decision, which is now taking some of these cases out of federal court and into state court.
Which actually is kind of an interesting plot twist, right? Because, I mean,
yes,
a lot of times it may be better to have these things in state court for a number of reasons. I mean, I guess traditionally they're a little more like easier to navigate through. You don't have judges who are appointed for life. Usually the judges are kind of like politicians. They got to get reelected every few years, and they want to, and I mean, let's be honest, who loves the credit bureaus and the debt collectors, right? When you got to get reelected every 2 years, no matter whether you're a judge or a city councilman or whatever, it doesn't matter. So it used to be, right, like FCRA was kind of like they would say that it trumped. Well, so let's back it. So you've got a lot of states have state versions of the FCRA, and people try suing under those. And it's kind of like a roll of the dice. Sometimes they get removed to federal court. Sometimes they can stay in state court. But what we were just talking about was, so what the Spokeo decision says is, okay, if you're going to, so what I was asking Ari for our viewers here earlier before we started. So basically, obviously a law that is unconstitutional is an unenforceable law. Let's just kind of start with like the very basic premises, right? So what they're saying is that in order to be able to have a court case in federal court, federal courts are authorized under Article 3 of the U.S. Constitution. So that's where your authority to even have a federal court comes from. And then so Article 3 is interpreted that you have to have a controversy or a dispute, which is interpreted that you have to have, i.e. damages. You have to be able to demonstrate that whatever you're suing for, you got harmed. So provisions of the FCRA are purely technical. They say that, hey, if the credit bureaus so they're required to have reasonable procedures to assure maximum accuracy, reasonable procedures while reinvestigating, which means if you send them the dispute, they're supposed to fix it or delete it. They're supposed to respond within 30 days. As we all know with COVID, credit bureaus have not necessarily been responding in 30 days. Under the FCRA, as it is written, you should be able to sue for negligent or willful noncompliance. But under the precedents, that's not necessarily the case, because this one case argued successfully that, well, although the law says that, they have no standing to sue in federal court because federal court requires that there are damages, and it was determined in this case that there were no damages. So therefore, although Congress wrote in the law that you can sue for whatever the case, let's just say not responding in 30 days, just as an example, if there's no damages, then there's no standing to take that. So I was like, Ari, does that mean that you just like can't sue for these provisions? He's like, well, no, you can sue in state court potentially and not federal court. So let's talk about that, because that is a more favorable venue if you can get there. Is that a fair statement to say state court is where you'd prefer to be?
I would prefer federal court.
Would you prefer? Okay, why is that?
I think the judges are more knowledgeable. There's been a lot of plaintiffs' lawyers that have been building these statutes and suing for years. I think we have a more difficult time in state court because the state judges are just not as familiar with the law. So it takes some time to educate. The other issue I find a lot in state court, and I'm not saying federal court is always the better venue. We're just more comfortable there. But as I was telling Steve, a lot of the state court judges used to be private practitioners. They used to work for a firm. And they used to do debt collection themselves. And sometimes I go in there and I explain why a debt collector did something wrong. And sometimes it's mainly like a technical type violation. Hey, you left out the word in writing in the validation notice, or you didn't properly state the amount due. You didn't notify us that interest was accruing. Whatever, one of many different things. And we'll get pushback from the state court judge because he or her when they were doing debt collection, they used to not do it the right way, and they're kind of shocked, telling me, well, if that was a violation, then I was violating the law for 10 years as I was doing debt collection. So it does take some education. A lot of times the state court judges don't have it. So I actually prefer to be in federal court, but if we're stuck in state court, then that's fine also. I just want to correct Steve on a couple of things, and I know Steve was just reading up on Spokeo, so he doesn't have the total analysis. Spokeo did not rule that the plaintiff there did not have standing, or that didn't. What Spokeo just did is it said the lower court didn't properly put the analysis through, and it got sent back down to the lower court. But what the Supreme Court said in Spokeo is that if you're going to sue in federal court, you need to explain to the court in your complaint what the harm is that your client suffered. So Spokeo was a website which listed people's information, and it worked like many websites. You type someone's name in Google, and Spokeo was just one of those websites that claimed to have information about you. And this plaintiff, looked at his profile, and he noticed that a lot of the information was inaccurate, like it had the wrong zip code. And it stated that he was employed when he wasn't employed, or it stated he was married and he wasn't married. And what the court's saying is not that that's wrong, that's not a violation because you weren't harmed. The court was just saying, you need to tell us what the harm is, or what the potential harm was. So after Spokeo, there wasn't a huge impact on the federal practice initially, because all plaintiffs' lawyers, including myself, all we did is we changed the way we drafted the complaint. We elaborated on what the harm is. And a lot of times we just had to plead a risk of harm. So we said, look, somebody has something wrong in their credit report. They dispute it. Experian didn't properly investigate. Now it's going to be more difficult for my client to get credit. And that was sufficient until very recently, until October of 2020, when a new case came down called Ramirez versus Transunion. And this is a very, very interesting case that has huge impacts on all of the consumer statutes, especially the Fair Credit Reporting Act. And what happened in that case was a plaintiff was on the OFAC terrorist watch list improperly. He shouldn't have been on it. But Transunion had a list of supposed terrorists, and they listed, I think, about 9,000 people that should not have been on there, but they had a name that was identical to another terrorist, so they were on this list. And now all of these people were unable to get credit if they applied, and they were unable to fly domestically or internationally if they tried to get a plane ticket. And Transunion didn't care. They didn't put the procedures in place to ensure that these 9,000 people weren't improperly on this OFAC terrorist watch list. And that case went to trial, and plaintiff won, and there was some huge judgment, jury awarded, I don't recall offhand, but it was like a $60 million judgment. It was some really big amount.
About 10 minutes worth of profit for the big bureaus right there.
Yeah, exactly. Yeah, right. Not that much money for Transunion, but a lot of money for these 9,000 consumers who were harmed. This case went up on like a Spokeo type argument, where Transunion argued that they didn't have standing, which seems ludicrous. Like, to be on a terrorist watch list when you shouldn't be on it, that, like, how is that not the harm Congress was trying to protect when they were telling telling Transunion and the credit bureaus to make sure that you have proper procedures in place. And what the court held there is interesting, and they kind of took a hybrid approach, but they said that you need to show harm. Risk of harm is no longer sufficient. And therefore, any of those class members who are on the terrorist watch list who either didn't know about it or never applied for credit were not harmed. Even though if they did apply, they would have been harmed, because they have not yet applied, or because they have not yet tried to get a plane ticket, they were not harmed. So they reduced the class from 9,000 consumers to down to like 3,000 consumers. And because they knew 3,000 people had their credit checked, because, as you know, you'll have an inquiry and you can look in. So why this is important for plaintiffs' lawyers and for everyone else is, if your client has a good Fair Credit Reporting Act violation. So if they have something on their credit report that should not be on there, and your client disputed it with the bureaus and they didn't do their investigation because they never do their investigation, and they sent back, yeah, we verify. We went back to the furnisher that you're disputing you owe money to, and they said that you owe the money, so therefore it should be on there, which is obviously not a proper investigation logically. We will not take the case to federal court unless there's an inquiry on my client's credit report. So unless I can show the court that my client went and applied for credit, and whoever they applied for now looked at their credit report, saw the inaccurate information, and that's the harm I could plead in my complaint.
Now let me kind of pause you right there. This is amazing, fascinating stuff. And so it would seem to me though that it's not a difficult thing. So if somebody comes to you, let's say for us as CROs and for all the folks watching here, right, this is actually a really important takeaway is if you're getting mortgage clients or whatever, hey, well, were you declined for your mortgage, right? Because sometimes you get somebody coming and they're just like, I was referred to you and I just really want to work on my stuff. All right, totally cool, but they haven't been damaged versus, dude, I just got declined for the mortgage and I've got a 575. Well, there's your adverse action, whether it's damages or not, is for the judges and all that to finally ultimately decide. But if you've been adversely affected, that's kind of your basis for your damages. So you had just said, well, you won't take a case into federal court unless there's an inquiry. So you could show that somebody looked at the credit. It would seem to me that if somebody gets referred to you and is like, look, I've got errors. I tried to correct the errors. They didn't correct them. They didn't delete them. So now this stuff is just like, shouldn't even be here. It would seem if they come to you and they haven't had an inquiry, you could say, hey, man, go to whatever, lendingtree.com and apply for a mortgage or apply for something. Let's get you the adverse action notice. So let's just talk real quick about kind of that aspect of it. When would you have somebody, see if they get damaged versus, oh, my goodness, you don't have damages and I can't foresee you having them, so I'm going to have to file in state court. How do you make that decision as a judge or as an attorney?
That's a really good question, Steve. So, and I want to explain a nuance because it's strange and it's really unfair to the consumer. And you picked it out perfectly. If a consumer comes to me because they were previously denied credit, which is the fact pattern that you presented, they applied for a mortgage, they were denied because their credit's bad. They look at their credit. It could be the first time they're looking at their credit report in their life or in years, and they go, oh my gosh, there's all these things on there that shouldn't be on there. I was a victim of identity theft or whatever the issue is. That's not enough harm to go to court because, as you know, Steve, the violation only occurs after you dispute it with the bureaus and give them that opportunity to cure. So we can only sue for any harm post-dispute. So even though there was previous denial, that's not sufficient to get into federal court, which you pointed out. We like to have organic cases, meaning we're not trying to tell people to apply for credit when we know they're going to get denied. As everyone knows, it's going to hurt their credit more, and some people, that's more important than filing the lawsuit. So if organically they come to us and they have inquiries after the dispute, we're going to file in federal court. If not, then we're either stuck in state court or we're going to have to wait for some time in the future when they're going to have to apply for credit again.
I mean, so is there some reason, like kind of as maybe like a matter of law or making you look bad in the case why you wouldn't want to do it? Or is it purely just strictly like you had said, hey, we don't want to put another hit on your credit and lower your score another 10 points? I mean, is it bad for the
It's a little bit of both.
If you're like, yeah, they came to me and they, but then we sent them the rocket mortgage and, they got the notice. Like,
yeah.
To me, it doesn't seem like a big deal. Is there a legal reason or is it just more like you want to preserve the credit?
So I think the defense would have a good argument if you ever get down to it and the consumer admits, I only applied for credit so I could sue in federal court. They're going to then argue, well, you're not really harmed because you're only applying for credit so you could sue us. It's sort of, under the TCPA, you sue people who are calling you that you don't want those phone calls. They're unsolicited phone calls. If you scam the person to call you because you wanted to later sue, you're going to have a difficult time convincing the court that you were harmed and you're entitled to
It's
damage.
kind of like this scenario. We're kind of joke. By the way, here's a disclaimer, right? So this show is purely for entertainment purposes only, and nothing we say here should be taken seriously. Okay. So it's kind of like if I come to you and I'm like, look, I'm planning on killing somebody over here, and I want to go ahead hide the knife after. You're like, oh my God, you can't tell me that. Now I've got a moral duty to report you. Versus, I come to you after I kill them and bury the knife, and then you're like, okay, cool, no problem. Let's put your defense together. Is that kind of what you're saying there? It's kind of the same thing.
It's a good comparison. I'm more concerned with, like I said, I'm more concerned with the standing argument. And the standing argument is we have to show the court that you were harmed. So it's a much better story to convince the judge that you have actual damage and you're harmed if you applied for credit for the purpose of applying for credit as opposed to the purpose of suing somebody.
And so we got Robert Sigmund here, our famous Kredzu good friend here. He says, how much will you pay me if I get them the inquiry? We love the humor, but let's actually get serious here. That's a good point. So, Ari, we're talking to CROs here. We're talking to people who get paid by consumers to help them improve their credit. And part of that is helping them get new, rebuilding credit builder lines, and then you putting them in a position where they can get whatever credit they ultimately want to get. And we should be, as CROs, thinking like Ari. We should be thinking and I mean, this just makes for a good client dispute relationship in general. You should do this on your intake. Have you been declined for credit? Why are you coming to me? What are your goals? Well, whatever. I'm wanting to get a mortgage, a car, a credit card, whatever. Okay, great. Have you? No. Okay. So we, as CROs who have licenses, not licenses, but under Credit Prioritizations Act, we have authority to give them advice and assistance to help them improve their credit. I mean, we got to help them figure out how to get where they're trying to go. We should be, especially if we're doing pre-litigation. I mean, there's no reason why we can't and we shouldn't have our client see if the fruits of our labor are going to get them where they're trying to go, which is after a dispute or two, hey man, let's get you back to the mortgage company, or you don't have one, good, go to one of these online mortgage places here, or the credit card company. Great, I got approved for the secured card with a 30% interest rate. Awesome, that's about as adverse as you can get other than being declined. You got a 30% interest rate and you had to put your own money down, as opposed to getting a 0% with free flight miles or whatever. So that's kind of how damages work. Could you have gotten better terms? It doesn't mean you even have to be declined, right, Ari? It just means you could have potentially gotten more favorable terms had these errors, if they are in fact errors, been corrected or deleted. Is that a fair statement?
100%. And then another way you can attack this is, even if you got the best terms, you can argue that you have some sort of invasion of privacy or embarrassment issue where somebody is looking at your credit and seeing that you owe Amex $1,000 when you in fact don't owe them $1,000. I mean, that's not, people don't want other people knowing that they're in debt, especially when it's not true. So the way you explained it is definitely more the way we go, where it's either you got denied or you got bad terms or you would have gotten better terms. Those are always good ways to attack standing arguments. And then if we have to fall back on it, we'll throw in some sort of invasion of privacy argument.
So, I mean, is it fair to say if we're doing a good job as CROs, and number one, we're finding real errors, and as I'm always talking about, Metro 2 is the Metro 2 format is the industry standard format for reporting accurate data. I mean, so if the data is all inconsistent among the bureaus, if there's fields that are not reported, if there's things that are clearly wrong, and you put them on notice of what's wrong, don't just say, hey man, prove it or remove it. But if you're like, hey, there's no date of first delinquency on Experian and TransUnion, what gives, even though this is a charge off, and it comes back 30 days later and there's no date of first delinquency. I mean, we don't even know if the thing should even be reporting, because that's where the 7.5-year purge comes from. I mean, it's just one example of a data field. So not to get into the splitting the hairs of which data fields do you like more or not for proving damages. But the point is, if we do a good job, put them on the notice of good factual disputes, and the data is clearly wrong. I mean, obviously we never know it's clearly wrong until the judge rules, but you get my point, right? If we can make a good argument, yeah, this thing's wrong, and doesn't even conform to your own industry standard, as an example. If we do a good job with good factual disputes with real errors and our client has been adversely affected, then is it fair to say that, Spokeo and then the subsequent precedents really aren't that big of a deal? You can kind of handle it as if it were kind of pre-Spokeo as far as your confidence and your ability to bring the claims and all that?
Yes, for sure. And I think in most cases, you're going to have an easier argument under the Fair Credit Reporting Act or the Telephone Consumer Protection Act to make those arguments, because those are harms that you can explain to a judge, you explain to a jury if you ever get to that point. And it's people are very concerned about their credit reports for obvious reasons and the impact that it has on their life. So yes, if you can build a good case, if you do everything properly, which includes, reviewing the credit report initially, finding the inaccuracies, disputing it, looking for the inquiries, yes, then we're back to pre-Spokeo days. We're no concern about any standing arguments.
So, I mean, is it fair to say, I mean, really, if we just go through the game plan that we just talked about, this isn't really as big of a deal as you kind of hear on the street. A lot of people are like, oh my gosh, Spokeo. I mean, we can't, there's got to be damages and all this. I mean, if we do this, you at least, obviously you can only speak for yourself, but you're feeling pretty good about taking on a deal. Is that fair to say?
Yes. Like I said, the only statute that I don't want to say that, but one of the statutes, the Fair Debt Collection Practice Act, was hit more significantly from this recent ruling, in my opinion, and mainly under the class action part. So for individual cases, you can show that your client was harmed, and your client can be deposed and explain the harm that they suffered. The issue with Transunion and Ramirez is the Supreme Court went further and said that you have to also show that the class members were harmed. And I don't want to get into the nuances of class actions, because we could talk for 2 hours about class actions.
That'll be for our next show.
So really,
for our audience.
Yeah, I would love to. I mean, that's my bread and butter, the class action fields. So that's where really the TransUnion decision had a huge impact, and that's where plaintiff attorneys are trying to get more creative now.
That's awesome. Well, I know we're kind of getting to where we want to wrap this up in a few, but I do want to shift gears a little bit to TCPA. You and I had a pretty cool call the other day, and you taught me you schooled me, as they say, on TCPA. And you were like, yeah, well, there's this Facebook precedent that kind of changed. And I'm like, how in the world does Facebook have anything to do with robocalling? Like, I've never gotten a phone call from Facebook. Does Mark Zuckerberg not like me? Well, I know he doesn't like me anyway. So, but he was like, you were like, well, they kind of had this campaign where they would text people like happy birthday, and that made me even more upset, Ari, because I'm like, Zuckerberg never texted me happy birthday. But you were like, look, there was this incident where I guess something glitched up in their system, and they sent this poor dude like 1,000 happy birthday texts, and he was none too pleased. He got an attorney, and they sued for the TCPA, which kind of prohibits robocalling, which is what we're going to talk about. And you actually, I learned something. So let's talk a little about what is robocalling, because my understanding had always kind of been, if somebody calls you with a recording, then it's kind of a robocall. And you were like, well, pre-Facebook precedent, the plaintiff's attorneys would argue that, but the defendant's attorneys would argue, well, robocalling was designed at the time to keep people with machines going through Excel sheets of like 100,000. No, just to keep them from going in sequential numbers, 555, 555, 5551, 5552, 5553. And you explained to me that was actually kind of the congressional intent of the robocalling, was to keep just freaking these companies from just like hammering every number combination and sequence to see who they can get and then giving them a recording. And if somebody is going to robocall, use a machine to call specific numbers of maybe clients that aren't like just sequential random numbers, that is not robocalling. And so interesting stuff. So let's talk a little bit about that. I know I completely murdered the whole thing there, but I kind of framed it up for our audience. So let's talk a little bit about that. What is robocalling now, and what can you do and what can't you do?
All right. So under the Telephone Consumer Protection Act, which is a federal statute enacted in 1991, what Congress said is that any company that's calling your cell phone, and on occasion landline. There's different rules, but I'm going to just stick to cell phones because everyone has cell phones these days and nobody uses landlines anymore. But if you're getting unsolicited phone calls with either a pre-recorded message or with the use of an automatic telephone dialing system, an ATDS, that you are entitled to $500 to $1,500 per call. So if you're getting any calls from companies trying to solicit you business or from debt collectors trying to call you to collect money, you may be entitled to compensation. However, if you gave them consent to call you, so you gave them permission at some point, then they're obviously allowed to call you. Here's where Facebook came about and all these issues. So pre-recorded phone calls are still part of the statute. So if you're getting any pre-recorded phone calls from anybody trying to solicit you business or from a debt collector, if they either do not have your consent or they're making the phone calls after you told them to stop, you may be entitled to compensation under the Telephone Consumer Protection Act. And the issue with Facebook came with what is the definition of an automatic telephone dialing system. So when the law was written in 1991, the software that was used to make these phone calls were very different and obviously way outdated to what they are today. But for the last 10 so years, they would use a system called a predictive dialer. And what that meant was a company would put a list of phone numbers together that they wanted to call. And the list could be 10 numbers, the list could be 100,000 numbers. It would go into a database. The software would then call these numbers randomly. It would just go through the list of numbers and just keep calling this whole list. And plaintiffs argued for a long time successfully that that is an automatic telephone dialing system because it's a machine calling. It has the capacity to call thousands and thousands of numbers every second. And it does call thousands of numbers every second. And the reason why it was called, I'm not going to get into the whole predictive dialer and all that stuff right now, but it was an easy argument to make. What defendants were arguing was that the law, the statute itself, reads that it's only a violation if they're calling random or sequential numbers. Random being, 7 random numbers or 10 random numbers or 11111, 11112, and just going through that list. No software does that. It doesn't make sense. No company would use a software like that. They want to call numbers that are active, that people have, and they want to call a list of numbers that they either think are good leads for a service they want to sell, or debt collectors want to call consumers that owe money or allegedly owe money. So for a while we've been successful. However, the Supreme Court recently ruled in the Facebook decision that in order for it to be an automatic telephone dialing system, it has to be calling random or sequential numbers. So it took out all the predictive dialer phone calls, most of the phone calls that come from debt collectors, most of the phone calls that come from banks. For example, I was telling Steve, we've had many cases. We had a trial in California pre-Facebook where Credit One was calling a 13-year-old boy. He got a new phone number. Whoever had the previous number obviously owed money to Credit One or allegedly owed money to Credit One. And Credit One had a policy of calling any debtor 8 times a day, no matter what, 8 times a day. So Credit One called this boy 8 times a day, 13-year-old, and he told him at some point, I'm 13 years old, I don't owe you any money, and they didn't care, and they continued calling. And he ended up getting 360 calls. We took it to trial. The jury awarded him $500 a call, which is $180,000. Unfortunately, post Facebook, we wouldn't have prevailed in that case because we wouldn't have been able to prove it's an automatic telephone dialing system. So TCPA took a huge shift recently, and now our firm is really focused on looking for either pre-recorded phone calls or what's called ringless voicemail. So ringless voicemail is a new software that a lot of companies are using where you'll get a phone call and it won't ring. You'll just get a voicemail. You'll look at your iPhone, you'll see a voicemail. I don't remember ringing because the software goes straight to your voicemail. And we've had some success arguing that that is an automatic telephone dialing system.
That's fascinating stuff. My goodness gracious. So let's see, we got Robert Sigmund. Let's see, definition of a call in a TCPA is even wider than TSR. Let's see, do you have anything you want to add about TSR, Ari?
I'm not an expert or very familiar with TSR.
All right, stay in your lanes. There you go. All right, and let's see, Cher. How are you, Cher? By the way, thank you for watching. Is this being recorded? Yes, it is. It's being piped in live, and so there will be the replay on all platforms, our YouTube, our Facebook, everything. So yeah, so as we kind of wrap this one up, I mean, yeah, hey, hi back. There you go. All right, so if we got any other questions, put them in here. But all right, this was some good stuff. My goodness, we should hope that John Watts is absent more often and you could fill in for him, huh? Let's just don't tell him we said that.
Yeah.
But you make for an amazing co-host. So if people want to get in touch with you, once again, which states, I mean, can you work in all 50 states with your referral network, or do you prefer just certain specific states?
So we have local counsel in most states. I'm not going to list off the ones we do or do not have, but we have local counsel in most states. We work in, like I said, nationally. So if anyone has any questions or issues around the country, you can feel free to email me. I'm not sure if Steve put my email up, but it's my first name, Ari, spelled A-R-I, at marcuszellman.com.
Let me put this up. Ari at Marcus. How do you spell the last part?
Yes, it's M-A-R-C-U-S. Zellman is ZELMAN.com.
All right, let's see. We are posting this up right here. I hope I got that. Look, it posted to my YouTube. I don't even know where these things are posted. My goodness gracious. Ari at marcuszellman.com. All right.
Perfect.
Email Marcus. Tell him that we want him to show up here on our show more often. You know, he was trying to get me to give him a booking fee of $10,000 for the hour. I'm like, no, man, come on. You know, I'd pay you 5, but not 10. So, but all joking aside, let's see, what do we got here? Ari is the best to, oh, well, so there we go, man. Look at that. We've got people who know, you keeping the poker face too, Ari. Yep. You're like, look, that's my client and I can't say anything, but it looks like Sherry, go ahead and spill the beans. So Ari is the best to work with. We love Ari. So that being said, reach out to Ari at marcuszellman.com. He is the TCPA guru. And of course, if you guys like what we're talking about here, we do have the training course, $99 a month, creditrepairtrainingcourse.com. Come check us out there. And so any final words here, Ari, for our audience, our fans, before we wrap this one up?
No, I really appreciate the time, Steve. This was a lot of fun, more fun than I thought it was going to be. I had a list of cases I wanted to talk about, but we didn't even get to it. So I'm hoping that you'll invite me back soon and we'll go through those cases.
Well, I'm going to wait. I'm going to wait for the public pressure to really build up on me, and then I'll be like, okay, I'm going to have to get Ari back. You know what? So he wasn't that good of a guest, but I'll do it just for you guys. But we like to joke a lot. All sincerity, we'll definitely have you back, man. This is good stuff, and I appreciate everybody watching. I appreciate your questions and stuff. And so that being said, we appreciate you guys watching, and we will see you guys on the next episode. You guys take care.
Thanks.